All right, there are a few seats down in front, so please feel free to come down and grab those. Good morning. My name is Elizabeth Andersen, and I'm the Executive Director of the American Society of International Law, and it's a great treat for us to welcome you all here to Tillar House for this discussion this morning about the International Criminal Court post-Kampala, after the review conference last summer, and on the eve of the first Assembly of States Parties meeting after that review conference. We are hosting this event here today as a two-part session. As the announcement indicated, we will start this morning with a discussion of U.S. policy toward the International Criminal Court and feature presentations by a number of ASIL members who have written for our discussion paper series about different aspects of U.S. policy toward the court, and those are published in the report that's on your seat. And for those of you viewing this by the web, that report will also be on our website. We'll then have a brief break for lunch and hear this afternoon from the director of the Trust Fund for Victims at the International Criminal Court, Peter Debon, and his colleague Kristen Kalla. They are both here already this morning, and I've encouraged them to chime in the discussion even before they take the limelight. So we're very pleased to have you here, and I'll begin with the first session. ASIL, as many of you know, is a nonprofit, nonpartisan membership organization dedicated to promoting greater understanding of international law. We do not, as a society, take positions on matters of policy, including with respect to the International Criminal Court. We see our role as a convener, providing a forum for exchanges of views and discussion of different policy options, and we see this project very much as part of it. We have, over the last 2 years, focused a considerable amount of our efforts on U.S. policy toward the International Criminal Court, in particular convening a task force in 2008, co-chaired by William H. Taft and Judge Patricia Wald, to look at U.S. policy toward the court and consider whether a new administration coming in 2009 should amend U.S. policy toward the court in any way, and in particular in the run-up to the review conference anticipated for 2010. That task force, two members of which are with us here today, Michael Newton and David Tolbert, was bipartisan and didn't always agree about everything, but quite miraculously, I think Mike and David will agree, did reach consensus around certain key steps of a new policy of positive engagement with the International Criminal Court. And specifically, the task force recommended a robust participation by the U.S. government in the Kampala Review Conference, and we've been very pleased to see that recommendation taken up by the Obama administration. The task force also recommended a number of additional steps, including a declaration of commitment to the object and purpose of the Rome Statute, a review of the American Service Members Protection Act, and U.S. Article 98 agreements with states parties to the Rome Statute. Those additional steps have not been undertaken by the Obama administration yet. And the impetus of the discussion paper series that you have before you today and our discussion today was really to look at those additional recommendations. Now, after Kampala, which understandably preoccupied the Obama administration in the first year and a half of this administration, now after Kampala, what about those recommendations that the task force put forward? Are they still timely or and appropriate? Have they been overtaken by events? To answer those questions, we asked 8 of our expert members who have followed, many of whom were in Kampala, many of whom have followed the International Criminal Court for over a decade, to help us review U.S. policy toward the court and make recommendations for next steps in this policy of positive engagement, or as the Obama administration has characterized it, principled engagement with an institution which is increasingly playing a prominent role in situations of great interest to the United States. We took as our point of departure the agenda from the Kampala Review Conference, which of course focused on the question of the crime of aggression and whether that should be included in the jurisdiction of the court, but also the stock-taking exercise that took place at Kampala, where states parties reviewed the issue of cooperation with the International Criminal Court, complementarity of jurisdiction between the International Criminal Court and national courts, the impact of the court on victims, and a fourth topic of stock-taking, peace and justice. We decided to commission papers, two each, on the crime of aggression, cooperation, complementarity, and impact on victims, and leave aside for this purpose the question of peace versus justice, which is maybe overarching, and I imagine we'll get into regardless today. Our 8 authors, 5 of whom are with us today, are well-known experts in the field, and I'm really grateful we gave them a very tight deadline to produce these papers in a timely manner so that it could inform discussion about the ICC in the run-up to the Assembly of States Parties meeting. And that was further complicated by the Thanksgiving holiday when our printer shut down. So we scrambled, and I'm grateful for their efforts over the last couple of weeks. I also want to credit my colleague Rachel Gore, who I believe is here somewhere and served as the managing editor for this project. On cooperation, we had 2 papers from 2 members. They unfortunately are not here. Professor Beth van Schaak, who is the associate professor at Santa Clara School of Law, and she served as an academic advisor to the U.S. delegation in Kampala this past summer, though, as a disclaimer in her paper indicates, the views there are, of course, her own, not those of the U.S. government. Also, on cooperation, we have a paper from Professor Ron Sly, professor of law at Seattle University. He is not here today, unfortunately, currently serving as a commissioner of the Kenya Truth and Reconciliation Commission and serving there. Then turning to the second topic, we had 2 papers on complementarity. The first from Leila Sadat, Professor Leila Sadat, the Henry Oberschelp Professor of Law and Director of the Whitney Harris World Law Institute at the Washington University School of Law in St. Louis. She attended the Kampala conference as a representative of the International Law Association American branch. And Professor Michael Newton is a professor of practice of law at Vanderbilt University and served the U.S. government in its Office of War Crimes issues back in the late 90s and was involved in efforts surrounding the Rome negotiations and the aftermath there, and a long-time expert in this area and member of our task force, as I mentioned. Turning to the topic of victims and the impact of the court on victims, we have 2 papers, one by David Tolbert, who is with us here today. David is the president of the International Center for Transitional Justice. He is formerly the deputy prosecutor, deputy registrar, and chef de cabinet of the president of the Yugoslav Tribunal. He served as UN special expert to the Khmer Rouge trials and as the registrar of the Lebanon Tribunal, an obvious expert on international justice issues, and served as one of the expert participants in the stock-taking exercise in Kampala. We also, on victims, have a paper by Valerie Oosterveld, who is on the Faculty of Law of the University of Western Ontario, and she served as a member of the Canadian delegation in Kampala. Again, writes and speaks here in her personal capacity. Finally, on the crime of aggression, we have a paper by David Scheffer, who has disappeared, but I believe is still on the screen there, is joining us from Chicago today. I think if you just, there he is. David is the Mayor Brown and Robert A. Hellman Professor of Law and Director of the Center for Human Rights at Northwestern University School of Law. He served as ambassador at large for war crimes issues from 1997 to 2001 and led the U.S. delegation at the Rome conference that negotiated the ICC statute. And finally, on the question of the crime of aggression, we have Professor John Cerone, Professor of Law and Director of the Center for International Law and Policy at New England Law. He is a frequent advisor to international courts and tribunals as well, serves as the co-chair of ASIL's Human Rights Interest Group, and was an ASIL representative in Kampala. And I want to also credit both Professor Cerone and Professor Scheffer for their timely blogs from Kampala, which helped keep the ASIL membership abreast of what was happening there. I think those are still on our website if people want to reminisce. A word about our format this morning. I will begin with a brief summary of the papers and the recommendations of the three authors who are not with us, and then we'll turn to our other participants, authors here, to present their papers and recommendations briefly. We will address cooperation first, then complementarity, then the impact on victims, and finally the crime of aggression. So we're not talking at you nonstop for over an hour. We're going to break topic by topic and open the discussion for questions from the audience briefly, and then resume our presentations here, reserving 30 or 45 minutes toward the end for a more complete discussion with all of you. We are videotaping our session this morning, and we will this afternoon as well. So I ask our speakers all to speak well into the microphone. And if you are posing a question, wait for one of my colleagues to bring you a microphone. Identify yourself and make sure that you speak into the microphone. So let me begin by presenting briefly the recommendations of our three authors who are not with us this morning. And as I mentioned, the reports and the papers are on your chairs as well. First, returning to the question of cooperation, state cooperation with the International Criminal Court. The first paper in our series is by Beth Van Schaak. She emphasizes the importance of U.S. cooperation with the International Criminal Court and identifies a number of ways, short of joining the International Criminal Court, that the U.S. can be supportive of the court and its accountability efforts, much akin to the way in which the United States supported the ad hoc tribunals for Yugoslavia, Rwanda, Sierra Leone, and so on. She outlines a range of ways in which international tribunals are necessarily dependent on states to facilitate their operations. These include arrests and surrender of accused, public outreach, diplomacy, procuring evidence, identification, training, freezing of assets, relocation of victims and witnesses and their protection, provision of security, logistical, and operational support for tribunals, accommodation and transport of court personnel, sanctioning uncooperative states, enforcement of orders for interim release, and enforcement of sentencing. Beth, in her paper, then takes aim quite clearly with the American Service Members Protection Act, which she sees as a major impediment to U.S. cooperation with the International Criminal Court at this point. She notes that the American Service Members Protection Act, or ASPA, prohibits much of the assistance that the International Criminal Court could benefit from the United States. There is waiver authority in specific cases when assistance is in the U.S. interest and the suspect is not a U.S. or allied special person, and there's a definition of that, of course, in the law. She also notes that there is a so-called Dodd Amendment to the American Service Members Protection Act, which specifies that the U.S. is not prevented, notwithstanding the ASPA, is not prevented from supporting the court in bringing to justice those accused of genocide, war crimes, and crimes against humanity. But she notes there is an unfortunate amount of uncertainty about the scope of the Dodd Amendment, whether it is case-specific or would prevent the kind of broad institutional support that the ICC might at this point benefit from the United States and that the U.S. would be interested in pursuing. And on page 11 of the report, she specifies a number of provisions of the ASPA that, in her view, are would be candidates for amendment at this point. And I commend those specific recommendations to you. Turning then to Professor Sly's paper on cooperation is somewhat different approach. He is less concerned about the American Service Members Protection Act. He has a construction of the Dodd Amendment that, in his view, permits much of what the U.S. wants to do or should want to do in support of the International Criminal Court efforts. In particular, he emphasizes the value of quote-unquote indirect support for the court, and specifically support for domestic capacity building and rule of law development in ICC situation countries. That is the kind of positive, so-called positive complementarity that support efforts by situation countries to complement the ICC's efforts. And I think we'll hear more about that from Professor Newton. Professor Sly also focuses particularly on the issue of arrests, and I think all would agree that this is one of, if not the biggest challenge facing the International Criminal Court at this point, and Professor Sly identifies a number of steps that the U.S. Could take to support efforts at arrest, including military, intelligence, and other assistance to countries in a position to arrest indictees. Again, indirect support that he sees not barred by the American Service Members Protection Act. He notes the value of diplomatic or sanction power to reward or punish states for cooperating with the International Criminal Court. And this was, of course, something that was used by the U.S. and others to prod countries in the Balkans, for example, to arrest indictees before the International Criminal Tribunal for Yugoslavia. And Professor Sly notes that this might be used in this context as well. Finally, he identifies the possibility of direct action by the U.S. military to arrest indictees. He does not see this as barred by the American Service Members Protection Act in light of the Dodd Amendment. However, he does note that there could be problems under Article 98 agreements between the United States and 3 of the situation countries before the ICC, the Central African Republic, Uganda, and the Democratic Republic of Congo, and he urges that be addressed. So those are our papers on cooperation, and I'm sure give us much to discuss. Turning then to our second topic, we have a first paper by Professor Leila Sadat on complementarity. I would commend it to anyone interested in this topic. I think it is one of the clearest, most straightforward kind of introductions to the issue of complementarity that I have read, and I'm going to assign it in my course that I teach on the International Criminal Court this summer. It explains the concept of complementarity in jurisdiction between the International Criminal Court and national courts, its basis in the Rome Statute, and she surveys early court jurisprudence on complementarity or admissibility of cases in the face of complementarity objections. She notes some issues with this early jurisprudence, which has required for a national process to bar ICC action that the case must encompass both the person and conduct before the court. And I know that Professor Newton also is preoccupied with this jurisprudence and will discuss it in his presentation, so I'll leave it at that. Much of Professor Sadat's paper focuses on the prospects for U.S. support for positive complementarity. That is how, through rule of law assistance, the U.S. can support domestic capacity building. She notes, however, that while the U.S. is already doing much of this rule of law development work, even in the situation countries, there is a need for that assistance to be consciously tied to the International Criminal Court. And she recommends an interagency working group to manage that assistance and ensure that it is as effective as possible. Finally, she recommends incorporation of ICC crimes into U.S. legislation. She notes that U.S. legislation already encompasses war crimes and genocide as required under the International Criminal Court, but that there is need for articulation in U.S. law of crimes against humanity. And this, she thinks, would give the U.S. the capacity to prosecute those charged with such crimes who may come within our jurisdiction, and will help the U.S. embrace positive complementarity, not just for less developed countries, but to play a role in implementing that concept as well. So with that introduction on both cooperation and complementarity, I'll turn now to Professor Newton to present his paper and recommendations. Mike?
Well, as the first live speaker today, other than Betsy, I want to thank Betsy. And I want to thank all of you for coming today in the sense that I think this is exactly the kind of thing that the American society ought to be doing, fostering open, candid conversation, really pointed recommendations. And when you read the report, which I highly commend to you, the differing perspectives really do provide this nice overview. And to that extent, take your copies and read them. And so I'm going to use my 5 to 7 minutes to give you a quick overview. Leila's paper and mine both address the subject of complementarity from somewhat differing perspectives, but in the aggregate, they nicely complement each other, pun intended. The concept of complementarity, which I take for granted most of you all are very familiar with, I won't spend much time explaining, except to say that it's a bedrock principle of the court, both for pragmatic reasons and, in fact, in the context of the negotiations in Rome, the complementarity concept and the implementing mechanisms in the rest of the Rome Statute were one of the fundamental points of agreement that allowed so many other points of agreement to flow from that. And so complementarity is not just this intellectual thing we want to separate and tease out. It really is integral to the fabric of the court in practice and in law. But I also think it's an essential manifestation of a healthy court. And the way I've said it in my paper is that complementarity was never intended to create institutional superiority on the part of either the court or domestic states. That there needs to be a healthy synergy and a healthy cooperative regime. And so the challenge today is how to go forward in that. Both Leila and I review some of the earlier jurisprudence in our papers, and I think it's fair to say that you really haven't had yet a real clear clash of complementarity yet. There's been every case that's come along in one way or another is distinguishable and really doesn't present too much of a difficult issue to date. So I say that to say that we really do have this nice window of opportunity to strengthen complementarity. One more point about U.S. policy, and then I outline my policy recommendations. It's important to remember that the U.S. policy of strengthening domestic mechanisms and domestic processes predated both the entry into force of the Rome Statute and certainly the Kampala Conference. It's a long-standing U.S. policy. The difference, I think, today, and the reason I say we've got a clear window of opportunity, is the optics. Prior to Kampala, prior to our participation in the review conferences and the discussions on aggression, it was really easy for people to portray a policy of U.S. support and U.S. strengthening of rule of law mechanisms and U.S. Development assistance in transitional justice systems. It's really easy to portray that as this sort of latent passive-aggressive hostility to the court as an institution. In other words, the only reason that the U.S. would do that would be to undermine the court, to undermine the foundations of the court. I don't believe that was true then, but after Kampala, it's clear that it's absolutely not true. The delegates in Kampala, I think deliberately, dramatically, reaffirmed the principle of complementarity, and in fact, overwhelmingly reaffirmed that support to domestic institutions really does reflect what I've called a principled harmony of values. It's the pursuit of justice in whatever forum makes the most sense and is most likely to succeed. And if that's the ICC in some context, great. If it's domestic systems, great. And the prosecutor has said that. But I think the optics are different now, so that the U.S., in fact, has a window of opportunity in its own right, but also a window of opportunity to work with friends and allies in achieving those same results. And so the way I've said it is that justice is not and should not be portrayed as a zero-sum game, where it's either the ICC and it's detracting from sovereign states, or it's sovereign states detracting from the court. It's a holistic synergy. They all work together to achieve what I've said, the principled harmony of values, the pursuit of justice and accountability where it's appropriate and where it's attainable. Which leads me to my 4 recommendations, which begin on page 32 of the report. The first one, no shock, no surprise, and Leila and I agree absolutely on this, in complete agreement on this one. And I've called it revitalized development assistance focused on rule of law capacity building including that which enables domestic states to satisfactorily achieve complementarity. Now, the U.S. government has a wide range of programs. As I sit back and look at those programs, though, I don't see that they're very well coordinated. And I like the way Leila has said it. They're certainly not undertaken with a specific focus on complementarity in situation states. I think we can do better than that. I think we can do better both in the orchestration of those policies and in the implementation of domestic rule of law assistance. We have the mechanisms in place as the United States to do that. We have the funding mechanisms, we have the ability to do it, but we're not coordinating them in a comprehensive way with a specific focus on complementarity. And I don't think we should be, as a matter of U.S. policy, shy at all about saying we are in this situation to strengthen the complementarity rights, the sovereign prerogatives, the sovereign right of that country to deal with its own issues. And we're helping in the best way that we can. The second point flows from that, which is on page 34, which is that there's a lot to be done in the broad rule of law context. In the narrower sense, though, I think there's also a great deal to be done with regard to the specific development assistance aimed at implementing domestic legislation that satisfies complementarity. I worked with the Ugandan government for some months prior to Kampala. Just prior to the conference, they did in fact enact their own domestic statute, and it was healthy, it was good, it was constructive, and it was overwhelmingly welcomed in Kampala. We need to replicate that in many other countries. And to that end, I think the United States needs to have a specifically designated team of real experts and the ability to get those experts in and help those countries, because there's a whole range of issues that surface in the context of domestic legislation. There's sovereign immunity issues, there are nullum crimen sine lege issues, there are the interface between international norms that derive from international law that are now being implemented in the fabric of domestic law. Every country that confronts these issues, whether it's the Ugandans or the Kenyans or the Iraqis that did the same thing, or states parties that are ratifying the statute and then implementing, all confront essentially the same range of issues. We need to have a team of experts that can fly immediately to assist that, which leads to my third point on page 35. And I confess that this is something of a peeve of mine, a trend that I want to caution against and that I think clearly supports U.S. policy. And it's simply this. There is nothing in the Rome Statute that requires domestic prosecutors to use exactly the same charge, exactly the same formulation. Article 20 focuses on conduct, and I think that's where we need to stay focused. So to require from the ICC perspective that a given set of charges follow exactly the same format, exactly the same charges, and if they don't, well, that can't mean that a state is genuinely able and willing to prosecute, after all, says the prosecutor and the pretrial chamber, because they're doing something different. They're not prosecuting. I think that's wrong and incorrect as a matter of law, both from the Rome Statute and from the negotiating principles. And I think the United States needs to stand on the side of those states that in their own way implement these norms and enforce them. And this is close to home because in U.S. practice, when we charge war crimes under the Uniform Code of Military Justice, we charge the underlying conduct based on the Uniform Code of Military Justice. We could easily find ourselves in 15 years in a situation where external observers point out, well, you've charged underlying conduct that we would call a crime against humanity, for example, but you didn't term it the exact same thing. We're using perfectly valid domestic statutes that could be taken as a prima facie indication of non-complementarity or admissibility. I think the United States needs to assist those states that want to challenge that at every turn. And then lastly, I agree with Leila that we need a specific interagency focal point to handle these issues both prospectively and then in terms of the complicated range of issues. And one subtle point in this is that I think the court should adopt, and the United States should help with, a mechanism similar to what in the ad hoc tribunals is the 11 bis process, a process for transferring a case, for transferring evidence, for transferring really cooperative synergy. Cooperative synergy is not just a buzz phrase. It's not. There needs to be a mechanism in place that really does allow domestic states and prosecutors and investigators and police to work very, very even-handedly with the court on a basis of mutual respect and mutual cooperation. Now that's, of course, what we would want in Uganda or the Democratic Republic of Congo or Nicaragua or any other situation state. I think the United States needs to be in a similar position, partly to set the example for those states. What does it look like to have a healthy synergy? We can and should do that. So those are my 4 recommendations. I detail that one beginning on page 37. And the shorthand version, if you don't want to read both of those papers, is that there is a window of opportunity. Complementarity as a principle directly strengthens U.S. prerogatives, and in fact U.S. interests are served by that. And therefore there are some concrete things that both Leila and I have said that will assist that going forward, both as a matter of U.S. policy, but I think it needs to be repeated as a matter of U.S. policy, but also as a way of strengthening the operation of the court. And therefore, when we pursue a policy of what we've called positive complementarity, strengthening domestic states, domestic situations, it really is not on the basis of attempting to undermine the court, but strengthening a mutual synergy between domestic states and the court in practice. So.
Okay. At this point, we'll take a break from our presentations here and invite questions from the audience or among the speakers if you want to interrogate each other. And if there are no one who wants to jump in, I will maybe begin with a question for Professor Newton. And I want to push a little bit on this issue of the development of the court's jurisprudence on admissibility and complementarity, and ask you, you've signaled that in your paper that there may be some cause for concern in some of the early jurisprudence, suggestion that perhaps the court is looking too closely for that very close match between its case and the case before the national courts. What should we be watching for? What should the U.S. Be watching for in the development of that jurisprudence? What would give you comfort? What would be cause for concern? And further, in your suggestion that we work with various states who may be challenging admissibility along these grounds, do you have any concerns about the U.S. kind of overstepping its role as a non-state party? Is there a risk of the kind of backlash that we experienced vis-a-vis the Article 98 agreements and kind of meddling with the court's operations that way?
Well, I do think there's a risk of the perception based on the rhetoric and based on the sort of the experience of the Article 98 context. If you go back to the May 2002 Undersecretary Grossman speech, which I understand is still the current complete statement of U.S. policy. I mean, he made a pretty bold statement. He said, we will assist any domestic state that wants to strengthen its domestic systems. That's a big blank check. It's a big promise. So to the extent that we help those states in cooperating with the court and in challenging admissibility determinations where they think they're able, I think we also, on the backside of that, owe them our real support in developing those systems and developing those structures. Complementarity, it's worth remembering that on this issue, the United States and its allies, I don't think, are very far apart at all. I think we're in complete agreement. If you ask the Brits or the French or the Germans, they would look you in the eye and say that they have perfectly valid systems. They would not anticipate the ICC exercising authority over one of their nationals because they would deal with it. I think to the extent that the court recognizes that principle, and they talk about it a lot, but then in the next breath in the jurisprudence, there's these very subtle indications that I've pointed out in the paper that said, well, what we're really going to require is complete consistency of charging. I think to the extent that the court, and I've recommended an amendment in the paper that specifically says that the pretrial chambers will not second-guess good faith prosecutorial decisions. Now, that's inherent in the word genuinely in any event. But I think the key is on the good faith prosecution of the conduct, not the specific form of the charges. And I do think we have a role in helping domestic states do both pieces, as I've pointed out. One, in implementing their own domestic legislation, and having done this myself in countries around the world, I can tell you it's extremely difficult, because you're talking about the importation of these legal norms into domestic, into the domestic fabric. They're not familiar with it. It's extremely difficult. It's also politically laden and politically charged. So to the extent that the United States has a role in helping with that, I think it's all to the good. And as I said, I think the way to avoid the Article 98 perception problems is in the way we package it and in the way we approach it. Kampala was very, very constructive in that sense. And I really do believe that after Kampala, a policy of strengthening domestic states can't be portrayed in that same light as we're just trying to undermine the court. You know, it was such a ringing reaffirmation of the principle. I think it's in the way that we do it and in the constructive relationship that we have with the court. And to that end, I would also add my voice on the cooperation mechanisms. I know they're not here to talk about cooperation, but cooperation and complementarity go hand in hand in that way. The good faith demonstrations of an ability to make the court work when it's supposed to work. But when domestic states are functioning and able, we ought to assist them in the same way.
I think we have time for one more question before we move to the next topic. Suzanne.
Mike, I agree with your point that the same conduct, same test is problematic, but perhaps for different reasons. If, for instance, you have the accused is suspected of committing or being involved in 10 massacres, and you have the state, the domestic system, engaged in the prosecution or at least the investigation of 9 of those massacres, but the ICC chooses to prosecute or to investigate that last one, it's questionable whether or not in that case the accused should be before the ICC rather than the domestic jurisdiction, assuming there's good faith, as you mentioned. But I do think that there's a difference in prosecuting conduct as murder versus conduct, that same conduct as the crime against humanity of murder. And so I wanted to ask you, I mean, you mentioned we shouldn't be insisting on exact same conduct, and to some extent I agree, but there is a different message, a different kind of perception of the crime of murder versus the crime against humanity of murder.
I agree. Next question.
What should the U.S. do about that?
No, I do. The biggest part of the problem, and it's a two-sided problem. The biggest part of the problem is that there are a lot of states around the world that have not taken every single crime verbatim, cut and pasted from the statute. In some cases, they've been selected. In some cases, they've done it by reference. In other cases, they've simply dovetailed specific verbatim crimes from the statute with underlying domestic crimes and said, well, to get at, and we've done some analysis of what this looks like in practice. I don't think any of those efforts can be prima facie said by the court to be inadequate. It really is a question for domestic authorities, and I agree, there's a huge symbolic difference between murder as a crime against humanity and, in the United States, a RICO charge of murder, you know. But there's nothing in the statute that says that the court's judgment on that is inherently superior or inherently authoritative. And this is a key difference. You know, if you read the case law, as I know you do great work in this field. I know you've read all these cases. They go back to the underlying jurisprudence of the ad hoc tribunals, in which case there is a jurisdictional superiority. And I think what's needed at this point, and this is related, and it's the last thing I'll say, Betsy, I promise, is a clear affirmation by the prosecutor in practice that, yes, what we want are good faith domestic efforts, and where those good faith domestic efforts are underway, we want to help those. One of the small things that's happened in Uganda, for example, the Ugandans have an obligation under the Article 93 and following parts to cooperate with the prosecutor. They've done that to a large extent. So now they're investigating other cases, and they can't get statements, they can't get evidence, they can't get cooperation back from the office of the prosecutor. I think that's a problem, even where they want to take good faith. And part of the rationale for saying that is to say, but you're pursuing a different line of crimes than we want to pursue. I don't read that in the statute. What I read in the statute is, as I've said, justice is not a zero-sum game. If justice, true justice, is done at the local level, the prosecutor should applaud that and should assist that. And right now, there's not a clear mechanism going both ways for facilitating that. And I do see a big window of opportunity for the United States to assist both domestic states, but to do so in a way that is cognizant of and constructively contributes to officer-to-prosecutor capacity. So,
okay. I'm sure we could talk all morning about complementarity, but we're going to turn now to the impact of the ICC on victims and witnesses, and I'll turn it to David Tolbert.
Thank you very much, Betsy, and it's a pleasure to be back here. We spent a lot of time in this room here, and I maybe spot a couple of drops of blood left from the days of thrashing out our ICC recommendations. I will say that I think that the recommendations that we made of positive engagement, or what's now called principal engagement, were really quite in the forefront in Kampala, because the U.S. was very well represented. Harold Coe was there, Steve Rapp was there, and of course the U.S. never does anything small. They had the largest delegation, even though they were a non-state party. So the U.S. was all over Kampala in a lot of ways. And I think that's in part a result of some of the work that the society did. And great credit to you, Betsy, and the organization in pulling that off. I think it's also worth noting a couple of other things. And just to give you a flavor, before I talk about the victims' issues, just to give you a little bit of a flavor of what the discussion was like at Kampala and then what resulted. The stock-taking exercise in all four of these cases that we're talking about was a panel discussion of the issue by experts, or in my case, so-called experts. I was actually on 2 of the 4 panels and actually spent a whole day on the dais engaged in these discussions. Basically, a 3-hour session with about an hour and a half devoted to presentations or questions and answers among the panelists. And then in the second half with either questions or really statements by states and then non-governmental organizations. And so by the end of that process, a number of issues would have come out, and actually a pretty robust discussion on some of the panels, more so than others. And then in most cases, there was a resolution that was adopted as a result of those discussions. So that's to give you a flavor of what happened. And of course, there were literally several thousand people, perhaps, in the at least it looked like that to me in looking around the room, involved in this discussion, including all the state parties, some non-state parties, and a very large group of NGOs. So in the victims discussion, which I thought was a wonderful opportunity to bring a really important set of issues to the table, I must express a little bit of disappointment in our discussion. Radhika Kuraswamy, who's a great expert, lost her voice in the opening speech, and we had too many people on the panel, so the exchange wasn't quite as crisp as it might have been. But we did really engage on some critically important issues with respect to victims and affected communities. Now, some of what I'm going to say is going to dovetail into what Mike says, because Mike talked about, and the complementarity discussion, because I think these issues to some extent are interwoven and related. And I think that'll be a theme that we talked about. With respect to the U.S. engagement and discussion, I think it's important to note that the U.S. was there to talk primarily about aggression. Of that huge delegation, almost all of them were talking about aggression and dealing with aggression, and I'm sure David Scheffer will talk about that. And there was some focus on complementarity. In fact, the U.S. did a very interesting side event on the DRC and complementarity. But I'm not sure. You'd have to look hard for a word in the transcript about victims from U.S. delegation. So some of what we're talking about here is my views of what I think they should have said. I think and I also should also underline, I think, in starting off, that what we're all going to say are obviously constrained greatly by the fact that the U.S. is a non-state party. So I'm not sure, I didn't put it in my paper, but of course the first thing I would say is that if the U.S. was a state party, which I think it should be, the U.S. would be in a much stronger position on all of those issues. And a second matter that we have to recognize is the ASPA, the American Service Persons Protection Act, or Service Members Protection Act, does create a lot of constraints. And I realize the debate that Betsy outlined between Ron and Beth, but it does place a number of constraints on bringing support to the efforts of the court. Let me just mention 3 areas that I think were important in the terms of the discussion, and that I would try to make some recommendations on. A large part of the discussion focused on victim protection, and that is the Rome Statute has moved the victim, I would say, from the object of the proceedings or on the sidelines or at best witnesses of the proceedings to actual participants. So victims have the possibility of actually participating in the proceedings in a way that we common law lawyers are not familiar with. It's based to some extent on the idea of partie civile in the civil law system, although there are a lot of differences between what's done in civil law and what happens at the ICC, and I can address that more in questions. But the victim and defective communities have moved, I think, in this process to the possibility of being to participate in the proceedings and to receive reparations. And there's a major development on the ICC statute, and particularly from the point of view of my organization, and that is that with the Victims Trust Fund, the link between the perpetrator, the traditional link between the perpetrator and the victim for the payment of reparations has been broken, so that it's possible to have reparations programs which address the broader needs and the broader or provide benefits to larger affected communities, not simply the ones who have the luck of the draw to have been injured or damaged by a wealthy or a perpetrator with assets. Most of the time that doesn't work. So the victim has been put in a very different place under the Rome Statute system. So three quick points and a couple of recommendations. One is in terms of victims' participation or victims' protection, let's put it that way. And this overlaps with the idea of witness protection, which has, of course, been a huge issue at the ad hoc tribunals and is an even larger issue at the ICC, given the context that many of these victims are coming from. Those are participating either as participants in the proceedings or victims who are witnesses in the process. The travails and the threats that these victims will suffer, and including threats against their life, including intimidation, are very serious concerns. And I think the U.S. can actually play a very significant role in this respect. While it's indirect support in these affected countries, in the countries that are ICC countries, ICC situation countries, the U.S. is generally and almost across the board the biggest rule of law assistance provider in terms of providing development aid, and is working on a variety of rule of law programming. This includes, and I have a lot of experience from my time in the Balkans, of witness protection expertise that was provided from witness protection programs in the United States, which is, well, we can have an argument about the Canadian Mounties, which are very good too, but I think they're probably 1 and 2 in terms of witness protection in the world. And this expertise, I think, can be provided without violating ASPA and providing direct assistance to witness protect in terms of building witness protection programs in country. And I think it also goes to this issue of positive complementarity. And I'll try not to talk about it too much because it's one of my real interests, but one of the great divides we have here are between those who work on international justice and those who work on rule of law development. I've worked on both sides, a lot more on the international justice side, but it's interesting that these two communities don't know each other very well, and for complementarity to work and for these issues relating to victims to begin to work, we need to bring those two communities together. And just as a very quick side note, ICTJ brought those two communities together a couple of weeks ago, and you can read the report on our website, www.ictj.org. I'm not running for office, but what we're trying to do is bridge these two communities so that the great deal of assistance that the U.S. and other states provide to rule of law development generally will have a much bigger impact on international justice. I've touched on participation. Participation raises a lot of issues. Maybe I'll take that up in questions. The third area I would note is reparations with the Victims Trust Fund, and you'll hear a lot more about that at lunchtime, so I won't go into great detail, but we had in the discussion the new chairman or chairwoman, Elizabeth Wren, who's chair of the Victims Trust Fund. And the Victims Trust Fund has already started to provide some programmatic assistance in Uganda with reconstruction of people who've had their noses and ears and so been defaced by the LRA. And I think they've assisted about 40,000 people at this stage. So there's a great deal of work that the Victims Trust Fund can do, and it's a great innovation. 2 points. One, it's terribly underfunded. I'm sure that the U.S. under the ASPA would not be able to provide direct assistance, but I think American citizens could, American organizations could. This is a really groundbreaking development in this area. The other thing is that, and this comes back to this coordination of rule of law development and what international justice actors are doing, is that programs such as DDR programs where you're demobilizing soldiers sometimes can be in great tension with reparations programs. Sometimes we see demobilized soldiers who have probably committed war crimes, and other serious violations, receiving much greater benefits than victims do under reparations programs. And there needs to be a great deal more cooperation and thinking through between those in the UN and on the rule of law side. And I think the U.S. could take a leadership role in this, in designing DDR and other programs in which you're working to try to construct a peaceful society and taking into account reparations programs and the rights of victims. Because if you don't address this properly, your victims today become disenchanted, and we have seen it before, potential perpetrators tomorrow. So I think this is another area where the U.S. could be very constructive. I'm sure I'm well over my 7 minutes, Betsy, so why don't I stop there?
All right. You can pass the microphone to Valerie.
Thank you very much. My paper focused also on victims' issues, but I took a gendered aspect, gendered lens in looking at what was discussed in the Kampala Review Conference. So just thinking backwards to the 1998 Rome Conference, in which we were drafting the International Criminal Court Statute, gender issues were everywhere in those discussions. They were in the discussions on the fair representation of female and male judges, in the difficult discussions on the crime of forced pregnancy.
It's 11 o'clock.
And on the term gender itself. The Kampala Review Conference was different in this respect, in that gender issues were not as much in evidence, but they were in the discussions of the impact of the Rome statute system on victims and the affected communities. So this is why I'm bringing a gendered lens to this discussion on victims' issues. Now, of course, I think that a discussion of victims' issues was a natural for the stock-taking exercise at the review conference because, of course, victims interact with the ICC in a number of different ways. They send communications or they provide information to the prosecutor. They apply to participate in proceedings, and some of them are admitted in as official participants in those proceedings by chambers. They serve as prosecution and defense witnesses. They may require specific measures of protection because of their specific involvement in the court. And they may receive reparations as a result of an order of the trial chamber. This hasn't happened yet, but it's a possibility. And they are recipients of project assistance through the ICC's Trust Fund for Victims, which we'll hear about later today. So obviously victims are crucial to the ICC's work, and therefore considering how many gender-based crimes have been charged by the ICC in the current situation countries, it's natural that the victim discussion should have a cross-cutting gender perspective. And this was agreed by the court, this was agreed by states, and this was agreed by NGOs as an important aspect of the victims' discussions. Now, you've heard from David about the official stock-taking discussions on victims' issues, which only lasted 3 hours. But I would like to point out that the stock-taking discussion on victims actually lasted for 2 weeks because it included various side events and various reports that were issued during the Kampala conference and also came out of the resolution that was adopted at the end on victims' issues. And that particular resolution references UN Security Council resolutions on women, peace, and security, as well as encourages the court to optimize its processes and field presence to improve the way in which it addresses the concerns of girls and women and victims of gender-based crimes. So looking at that as a whole, the official discussions and the side events and reports that were issued during the Kampala conference, I saw 3 themes related to gender issues that emerged on victims' issues. The first theme that emerged is that the ICC faces challenges in ensuring gender-sensitive investigations and prosecutions. It has difficulty in ensuring gender-sensitive protection for victims and intermediaries. And for those who are not steeped in the discussions of the ICC, intermediaries are those who link the ICC to affected communities. So in the case of gender issues, this might be women's organizations in the Democratic Republic of the Congo, for example. The second theme that emerged during these wider discussions on victims' issues was that the ICC faces significant challenges in accessing and getting sufficient information to victims of gender-based crimes, including women and girls, in the affected communities. And thirdly, the final theme that emerged is a very positive one, and that is that the projects of the ICC's Trust Fund for Victims have a significant and a needed gender component, and that this focus should be maintained going forward. Can I just give you a couple of examples that arose during these 3 different themes that illustrate some of the problems that the ICC faces in accessing victims of gender-based crimes? Some of them are very, very concrete. So, for example, we heard during David's panel about how women and girls often are not able to attend the in-person outreach programs of the ICC because they are busy in the fields, tending to children, or in the home. And then related to that is something that I think many, many government delegates hadn't thought of before, and that is that the man of the family often has sole access to the family radio. So if the ICC tries to compensate for the fact that women cannot come to these in-person outreach sessions by doing radio sessions, then they are still missing many of the women and girls who they otherwise would wish to get to. So this is a very concrete and specific example, but one that has far-reaching consequences for the work of the ICC. Now, where does this lead to in terms of recommendations to the United States? Well, assuming that the United States follows the case-by-case assistance promoted in Beth Von Schok's paper to avoid violating the American Service Members Protection Act, there are ways that the United States can assist in promoting gender-based justice in the ICC. One is that the ICC can provide on an ongoing basis, on a case-by-case ongoing basis, evidence or information on gender-based crimes happening in ICC situation countries. And Ambassador Stephen Rapp in particular has expertise on the prosecution of gender-based crimes and therefore is well aware of the kind of information that is particularly helpful to the ICC in this respect. The ICC, of course, can encourage ICC situation countries to ensure that they have appropriate protective measures in place to assist the ICC, including with respect to gender-based crimes. And the United States could share information in the way that David has pointed out on how to provide field protection for victims of gender-based crimes and their intermediaries based on the United States experience in this respect. And the United States could provide assistance and advice to ICC situation countries on victim and witness protection at the domestic level. So this goes, again, to the point raised by Mike on positive complementarity. But don't forget also that the United States has a role to play in the UN Security Council. The UN Security Council can adopt mandates that provide gender-sensitive assistance in particular ICC situation countries, for example, through peacekeeping. And lastly, internationally, it's important for the United States to continue to indicate diplomatic support for the arrest of fugitives by the ICC who are charged with gender-based crimes, as it recently did with respect to the October 11th arrest of Mbar Shumana. So just to conclude, I would also point out that the ICC, while under the American Service Members Protection Act cannot provide direct assistance to the Trust Fund for Victims at the moment, it can ensure that the U.S. international development funding complements the work of the Trust Fund for Victims. And this echoes what David was saying, and I think this is a very important focus for the U.S. government going forward. Thanks.
Okay. Before we turn to the crime of aggression, I'll pause there and see if there are questions on cooperation, complementarity, or impact on victims. Edwin.
Thank you. I'm Edwin Williamson, Senior Counsel at Sullivan and Cromwell. More questions on the complementarity discussion, but some of the questions that occurred to me is, why is it important that efforts by the U.S. to strengthen complementarity be tied to the ICC? I detect also, isn't there a tension between those who favor the ICC jurisdiction or have a suspicion of complementarity? In other words, there's the exchange on the issue of murder versus the international crime of murder. Seems to me, I think it betrays a lack of a true commitment to complementarity, and that there is, particularly in this community, a prejudice towards ICC jurisdiction. Now, one of the key things, and I don't think we ever got to the point of a direct discussion of it, but there's no doubt about it that part of the suspicion and hesitance by those, and I include myself, who oppose the U.S. accession to the Rome Statute, is that we really don't believe that the proponents of the ICC truly believe in complementarity.
I think, Mike, that's first and foremost a question for you, but I think others may want to chime in as well.
Well, the heart of the question is, why should U.S. efforts in terms of positive complementarity and strengthening rule of law systems be cognizant of the court? And I can only give you one very good example from within the last 2 weeks. from a diplomatic delegation of what should be one of our strongest allies. Delegate sat on the stage and he said, U.S. efforts to take leadership in restoring the rule of law and building justice and accountability mechanisms can never be taken as showing leadership and good faith until the United States is a full party to the Rome Statute. I personally disagree with that. We spend more, we have better expertise, we're able to get focus, and I think to the extent that we proceed in a vacuum, in a bubble, and we pretend like the ICC isn't there, and that there isn't a need for good, I call it synergy. And I have seen in practice sometimes, not always, but sometimes, a lack of good faith dialogue between the court and domestic officials. Partly that's the responsibility of domestic officials who have not been able to coordinate their efforts effectively, but it's also the responsibility of the court. I think to the extent that the United States can help serve a constructive role as a good faith actor to strengthen domestic accountability in light of what the court is doing, it's all to the good. And in fact, the core, from my personal perspective, is that it strengthens U.S. security. It's very much in United States interests, both in the moral, larger sense, but also in the very pragmatic sense. And that's why I think, my personal opinion, that it's quite appropriate for us to target efforts in full cognizance of where the court is operating and what situation states are, and what are potential situation states as well. It's not just that we're going to always react to the court. It's that the pursuit of justice and the rule of law strengthening is a prospective, proactive process that, in fact, over time, does serve U.S. interests. That's my opinion.
John, we haven't got to your paper yet, but punchline at the end is a recommendation for U.S. Joining the Rome Statute. And what's your answer to Edwin and his suspicion that those who advocate the U.S. join, that you don't really believe in complementarity? How do you, or maybe put it a different way, how do you reassure him that complementarity is real? Or how does the ICC reassure those who have this concern that complementarity is real?
Well, I think everybody agrees it's a basic cornerstone of the ICC system, and that really the ICC's ideal situation is not to have any caseload. The idea is states will take responsibility for prosecuting these things at the domestic level, and I think all ICC supporters would be happy with that situation. And the fact that the ICC exists is because, unfortunately, that has not tended to be the case. And on the more specific point about whether you have to prosecute specifically for the international crime as codified in the ICC statute, I don't think anybody is saying that domestically it has to be prosecuted as in the same terms as found in the ICC statute. Whether or not it is may be a factor in determining whether or not there has been a genuine prosecution. But certainly there are cases where the ordinary crime of murder is going to capture the conduct just as well as the war crime of murder under the ICC statute, and then complementarity would be satisfied, the case would not be admissible. So again, the correspondence of the charges, I think, is a factor in the determination, but it's certainly not dispositive.
Just one question to clarify. Mike Newton, what was you referred to the jurisprudence that developed in the ad hoc tribunals as to, as I understood you to say, the superiority of international justice.
Go ahead.
Go ahead, you can go first.
Well, the ad hoc tribunals convened under Chapter 7 of the UN Charter. All states under the UN Charter have the obligation to implement and to assist so therefore the prosecutor, when it wanted a case, as in the case of Todd, it's the very first case, the Germans were prosecuting that case. The prosecutor had an absolute right to say, I have a jurisdictional primacy. It's a very different structure than in the ICC, which is designed, and this is important because the ICC structure is not built, it's built as an integrated system. And what I'm troubled by personally, and I agree with John completely, we see the same on this, what I'd like is a simple statement from the prosecutor that says, and I've recommended on page 36 a specific amendment that states parties could consider that really does put the focus on good faith prosecution of the conduct. And I think to the extent that the United States, and not just the United States, but China and India and other states that are concerned about the ICC, it's very much in the court's interest to strengthen confidence in complementarity principles. I see that as a very essential part of the discussion between the court and the Assembly of States Parties and non-states parties. To the extent that there are excuses made and that there's always, if you will, or what's perceived as ways of bypassing complementarity, it really does undercut the outreach to non-state parties. And I think to the extent that the United States and other non-state parties work with state parties to truly make that an effective, viable, clear, operational, pragmatic regime, I think it's all to the good.
A couple of comments. Mike's absolutely right. ICTY is based on primacy. ICC is based on complementarity. I do want to just one very minor point vis-a-vis what Mike said earlier on the Rule 11 bis process, which I worked on extensively at the ICTY. It doesn't quite work for the ICC because it's really based on primacy of transferring cases back to the region and monitoring those cases and the ability to bring back. What we actually did, and the more interesting story at the ICTY, was the Category 2 cases, which are cases which were not indicted, which we investigated, and we turned over to national prosecutors. National prosecutors, then with some assistance from the ICTY, but, and what I think is a really interesting positive complementarity model, with assistance on the ground from U.S. Marshals, from OSCE, from the Office of the High Representatives, but throughout the region in the former Yugoslavia, then conducted their own prosecutions. We made our databases available, and it was very interesting. I've written several articles on this, and it's a long discussion, but a lot was accomplished in that way. That's not quite possible in the ICC context, and there's not the stomach or the will in the assemblies of state parties to spend another euro, and that's what they spend, on implementing these kind of ideas on in terms of positive complementarity. But to go to the question, today, there are not going to be any more ad hoc tribunals. Very unlikely to have any more special courts for Sierra Leone, I think. Very unlikely to have any more UN hybrid tribunals. We have a reality where we have, first and foremost, domestic prosecutions, and that's what Rome's statute says. The primary obligation is on the state. Where that fails, and clearly fails, where the state is unwilling or unable, then the ICC has the possibility to intervene, where we'll have a handful of prosecutions at the ICC. If you believe in the fight against impunity, you really have to believe in complementarity because it is the only game in town, and we have to strengthen domestic systems. And I think it's important for the U.S., which continues to be the biggest spender on rule of law development, to be deeply engaged in this process. And I think there were some hopeful signs in Kampala, but we need a lot more.
Mike has a 1-second point, and then we're going to get to a very big topic in the crime of aggression.
Yeah, and I don't want to take away from the crime of aggression discussion, which is so important. But I actually would push David on that slightly. I do think that the ICTY 11 bis system, which for those who are not schooled in this, is the process of transferring cases back to domestic jurisdictions that have already been within the cognizance of the court. I think at some point in the ICC life cycle, that may become a pragmatic necessity. And we've already seen instances where ICC action is a real spur and a real puts the real spotlight on domestic action. And in my mind, that's all to the good. So where there are situations that need to be transferred back, or particular cases that need to be transferred back, it does two things. It does justice, but it also does it at the local level. And it does it in a way that the ICC has a continuing relationship with those domestic processes, like what we've seen in the Balkans. I think that's all to the good. And therefore, the problem is right now in the context of the statute, there's no mechanism for doing that. And in my view, I think there should be, so that it's there at the point that it's needed.
I don't so much disagree that it's a bad idea. I think it's a good idea, and I think what we did in the Balkans, although I actually think we did a lot more in the Category 2 and the provision of information and data. I think the Rule 11 bis gets too much attention. It is the tip of the iceberg. There's a lot more that went on. I just don't think that there's a political will in the ASP or the primary donors for an 11 bis process. I wouldn't be against it. I just don't think it's going to happen. And I think what we have to do is work organically in state-by-state situations with rule of law providers and international justice actors. And I'm with you. I think the ICC prosecutor's role ought to be to help enable those prosecutions and investigations. In fact, investigations even more than prosecutions. I just don't find, and we had a big meeting, we heard from all the actors, and every time the ICC suggested it was pretty clear that those who are paying the freight right now are not interested. Not that we shouldn't push it.
Okay. Well, obviously much more to discuss, but David Scheffer has been patiently waiting for us there. And David, if you can hear us, it's your turn now.
Thank you. Thank you very much. Tell me if you cannot hear.
Can everyone hear in the back?
I want to thank everyone for this invitation, and I wish I could be there, but I have to teach a class later today here, so I'm stuck in Chicago. I just wanted to say generally from all that I've heard this morning that I think it's extremely important to press this domestic rule of law support thesis that you've heard so much about this morning. I would just say that the political gut check in Washington is whether or not you galvanize the political will to put American financial and diplomatic support behind that endeavor. We have done a lot by the United States government, but there is so much more that needs to be done unless there is a political leadership both in the executive branch and particularly on Capitol Hill. I mean, who is the champion of foreign assistance for rule of law objectives on Capitol Hill? Please identify. Until you have that group on Capitol Hill that will push that agenda, it becomes a noble but sometimes unrealistic aspiration. So there's a huge amount of work to be done in Washington to really realize the aspirations of complementarity within the Rome Statute. Now, I want to dive into the crime of aggression here, and of course I've only got a short period of time, so I'm not going to repeat everything that's in my chapter in the discussion paper, but I'm going to sort of walk through major issues and then ask you to actually read the chapter to get the details. The first one that I want to point to is the definitional exercise that took place in Kampala, which ultimately became Article 8 bis in Resolution 6. Now, this is a formulation for the definition of both the crime of aggression and an act of aggression that frankly had been set more or less in stone prior to Kampala. So the debate in Kampala was really not around Article 8 bis or the definitions. However, the U.S. delegation arrived as a non-party observer state very, very focused on definitional issues. Having been absent for the prior 8 years in all of those discussions, they recognized that they had more or less a fait accompli being handed to them with regard to how to define this crime. But I think they made the best of it while they were there. The delegation was a very, I think, powerful influence in Kampala. I certainly witnessed them from my sort of academic perch there. And they made a difference in terms of understandings that they achieved agreement on among the delegations by consensus that provided at least some clarity to some of the definitional parameters. And yet problems remain. And I think it's just important to point these out. I think I discussed this in some detail on pages 88 to 90 of my chapter, where I think from a practical point of view, there's difficulty in looking at what is an act of aggression without establishing any magnitude test for it, no gravity test, particularly with the range of types of uses of foreign force that are listed there, arising from Resolution 3314 from 1974 in the UN General Assembly, but absent any gravity test. And then you try to marry that with a crime of aggression definition that speaks of a crime being committed if the act of aggression is of a certain magnitude that constitutes a manifest violation of the UN Charter. While you can technically make the argument that that makes sense, I think it's somewhat sloppy. And I think it will lead to certain difficulties in practice that I've tried to alert in my writing since Kampala, so that there's a lot of prep work prior to 2017 to ensure that people understand what the basic drill is in terms of referring a situation of aggression. What does that mean? I mean, does it mean acts of aggression? Does it mean you've determined that crimes of aggression appear to have been committed? What does that exactly mean? And when the Security Council refers aggression, what exactly are they referring to criminal court? Is there a basis for determining gravity when the Security Council acts? Now, this gets into considerable detail, and I'm not going to go into all of that. I'm just going to point out that I try to express this somewhat on pages 88 to 90. I do it in more detail in my law review article in the Leiden Journal of International Law, in an article called The Complex Crime of Aggression. And I don't think this is not a deal killer or anything. I just think everyone needs to focus on this a little bit and gear up a better understanding of how this will work in practice, so that we don't have unnecessary chaos when 2017 comes along and we suddenly have allegations that people are politically manipulating Article 8 bis to sort of dump de minimis acts of aggression on the ICC, and then we've got to scurry around to determine whether in fact even a crime appears to have been committed, which is the basic referral mechanism of Article 13 for the other atrocity crimes in the Rome Statute. So anyway, I put that all out in front of you without any detailed explanation whatsoever. Understanding 6 and 7, which the United States delegation pushed hard for and successfully achieved, provides some clarity to this, and that's good, but also leaves it a little unclear, and I think technically a little bit incorrect in how those understandings are actually expressed. So all of that is, as my colleague Bill Shavis in Kampala turned to me once and said, my goodness, are we going to have a lot to talk about for the next 7 years? And I think that's exactly what will develop, even though I'm very supportive of generally what has come out of Kampala. I think it's in the details that we need to keep focusing. Now, the jurisdictional filter, don't call it a filter anymore, jurisdictional filter that emerged in Article 15 bis has its complexities. It has every impression of being a heavily negotiated filter, but that's the nature of the beast, and frankly, I think the process came out just about as well as it could under the circumstances in order to get a consensus, as well as to frankly preserve as much of the Security Council's, shall we say, jurisdictional prerogatives, if not primacy, with respect to aggression as was possible among so many governments, most of whom simply despise the Security Council. And certainly in sidebar conversations made that very well known in Kampala. So I think you have to look at this not in terms of what would you have preferred from an American perspective as the most perfect formula, i.e. Security Council primacy, but rather what in the real world could you achieve and get as close to that as possible. And quite frankly, I think Article 15 bis gets you there in the most pragmatic sense possible. There are a few things which I think are missing from Article 15 bis, which we have to sort of flag for pragmatic purposes. If the Security Council were to render literally a negative determination on aggression in the future, and let's say a Chapter 7 resolution saying, you know, the Security Council is going to do X, Y, and Z, set up an enforcement force or peacekeeping/enforcement, whatever, and do 1,000 different nation-building things in this failed nation. And by the way, we want to remind everyone that it is our determination that aggression has not occurred in this country, hint, hint to the ICC. There's nothing in Article 15 bis that enables the ICC or that requires the ICC to literally honor that Security Council determination that there has not been an act of aggression. So please do not go down that route. Rather, everything is framed in terms of, will the Security Council make an affirmative determination on aggression? If it does, then the pathway is fairly clear for action by the court. You know, if there's a state party or a prosecutor initiated investigation, then Article 15 bis gets you going. If there has not been a Security Council determination, affirmative one, on aggression, then you go into the 6-month waiting period, and if at the end of that 6-month waiting period there still is no determination, then the pretrial division, which is all of the pretrial judges, not just the pretrial chamber, but all of them by majority vote, then can push the investigation forward with the red light available by the Security Council to come in with a Chapter 7 resolution under Article 16 and shut it down for at least 12 months. So that was the constructive compromise, and all I'm pointing out is it is not beyond the pale of imagination that the Security Council, under some interesting set of circumstances, wants to send a very clear signal to the ICC that this is not an aggression situation in terms of their judgment at the Security Council, and so the ICC, if it were to proceed, should actually focus on the other sets of crimes and not on aggression. The other issue that we should all be aware of is the role of the judges on aggression. There is terminology in Article 15 bis 8 and 15 Tier 4 that determination of an act of aggression by an organ outside the court shall be without prejudice to the court's own findings under the statute. That's fine, but it should also be recognized that once the court is seized with, and again, this is sort of my terminological confusion about what I exactly say, is it seized with a crime of aggression or a situation of aggression? But once it's actually seized with it, with all of the Security Council traps having been, dealt with, do the judges on the Security Council sort of de novo look at the issue of aggression and reach their own judgment as to whether or not acts of aggression have occurred, whether or not a crime of aggression has occurred? That gets them into a realm of state responsibility evaluation that typically we've reserved to the International Court of Justice judges and, of course, politically to the Security Council. So we just need to be aware that we have vested the ICC judges with a new realm of jurisprudential power here with respect to the crime of aggression. And that leads me to some of my, at least one of my recommendations, which is one of the things the United States can do without violating ASPA at all, for Pete's sake, is to work the system a little bit over the next few years. It would be useful if of the 18 judges at the ICC, we see at least 2 or 3 maybe who are retired military judges. I mean, I've always argued the first U.S. judge at the ICC, if we become a state party, and I, as you know, have been advocating that we move in that direction, that we look to our retired JAG Corps officers, for that purpose, because it would be very useful to get a military judge on that panel. But I've also recommended that we consider the possibility within the framework of the judges to create a special panel similar to the ICJ special panel on environmental issues that focuses, frankly, on the the skill of evaluating state responsibility for aggression and to bring seasoned international lawyers who understand that issue very well into that dynamic. Finally, there's the temporal tryst in the amendments for aggression, which we shouldn't overlook, because what happened in Kampala was fascinating. There was a lot of sui generis thinking about how you reach compromise before this crime is actually activated. And there's a requirement that at least 30 state parties ratify the amendment, which Article 121.5 doesn't say anything about. And yet there's a walkback from 121.4 that says, okay, 30, but you don't need 7/8, which is what Article 121.4 requires for amendments. So there was that juggling going on in Kampala, very, very interesting, and it led, and this is where I'm going to finish, it led to a very interesting discussion with a major state party at Kampala. Many of you will know who this is. And that state party has expressed itself in many ways since Kampala. And I'm wondering, quite frankly, what will happen at the Assembly of States Parties meeting in December on this issue, or what dialogue will take place. I wish I could be there for it. But that state party has, I think, articulated an idea that I just want to dump on you, and then I will be very quiet, okay? There is kind of a disconnect that could be an interpretive disconnect between Article 15, Bis 4, which is where a state party or the prosecutor refers a situation, and it says that there will be coverage on aggression unless the state party has filed its declaration of non-coverage. And the impression left is that it covers any state party unless that party has filed a declaration, even if the state party has not ratified or accepted the amendment. That's an interpretive issue that conflicts with paragraph 1 of Resolution 6, which says all of this is subject to paragraph 121.5, which says there's no jurisdiction unless the state party has accepted the amendment. So there's a little bit of confusion there in the drafting. And there is a way to solve that problem, I think, with everyone understanding that Article 121.5 prevails, that it is the operative provision on that issue of whether or not a state party is in fact covered by the crime of aggression. You look for whether or not it has run the traps of 121.5 rather than the sort of ambiguous language of 15 Bis 4 on that issue. That is a very big issue with a major state party, and we'll see if it comes out in the discussions at the APC, at the AFC. And one final little kicker. I look forward to the day when the prosecutor will have a huge map in his office. And that map will have all sorts of different colored pins on it. There'll be aggression-related pins. And they will try to plot the territorial jurisdictional reach of the crime of aggression globally based upon the Kampala formulation, because it will be complex. And you're going to kind of have to have a map in your mind to figure it out on any particular day. I'll close there.
All right, David, thank you very much. We'll turn now to John, mindful that we want to save some time for more discussion before we break for lunch. John.
Okay, I'll be quick. I'll just very quickly walk you over the sections of my paper so you can see generally what I talk about. It says it's on. Is it working? Okay. I start off with the historical position of the U.S. in relation to attempts to define aggression and point out that it's been relatively consistent, but not entirely. Starting with after World War I, U.S. Objections to attempts to prosecute the Kaiser, the U.S. taking the position along with the other delegates that there's no positive law on the jus ad bellum. Then we have the Kellogg-Briand Pact, which the U.S. becomes a party to, but at the same time reserving to itself the right of self-defense and also auto-interpretation, that the U.S. gets to decide on its own whether or not the right of self-defense has arisen. Then we have World War II, and we have the two major legal developments after the Second World War, the IMT at Nuremberg, also the creation of the United Nations Organization. The U.S. has different positions with respect to these two international institutions. For the IMT, the U.S. wants to include crimes against peace in the subject matter jurisdiction of the tribunal, and initially proposes a definition for aggression, which it subsequently modifies and then ultimately withdraws. At the same time, in negotiating the UN Charter, the U.S. takes the position that there should not be a definition of aggression in the Charter. There obviously are contextual differences. The Charter is not dealing with individual criminal responsibility. The IMT is. In the context of the IMT also, we have to bear in mind that it had very narrow personal jurisdiction. So the IMT could only prosecute those working on behalf of the European Axis, so no chance that it would apply to anybody else in any event. We see continued resistance to U.S. attempts to define aggression in the General Assembly, when the General Assembly was negotiating what ultimately became Resolution 3314. Also, if we look at ICJ litigation, most famously Nicaragua versus the United States, again, U.S. resistance to have an elaboration of the jus ad bellum, and in particular, to have that determinations be giving power to a judicial institution to make the determination of whether or not there's been a violation of the jus ad bellum. Of course, these concerns were also reflected in the Rome negotiations. At Rome, the U.S. very intent on preserving the Security Council's prerogative, exclusive Security Council determination. As we know, the U.S. lost that battle generally with respect to ICC crimes. Now, if we look at the situation or the posture of the Assembly of States parties in the lead-up to Kampala, as David was saying, there were a few things that were already pretty solid. One was the determination that aggression become operational. It had a tremendous symbolic importance for the majority of the states parties. Even some states parties that perhaps were more skeptical at Rome changed their mind through the course of the working group. So there was a consensus that aggression should be within the effective jurisdiction of the ICC. There was also consensus on the definition, which drew very heavily, of course, on that General Assembly resolution, which, as we've said before, the U.S. had problems with. But there were still a number of issues where the ASP was divided, including the proper procedure for amending the statute, the proper interpretation of 125 second sentence that David was referring to, implications for non-parties in particular, and most importantly, of course, that package of jurisdictional triggers remained quite contentious. U.S. objectives going into Kampala, of course, it was to follow this line of principled engagement, to try and bring more coherence to the U.S. position vis-a-vis international criminal courts and tribunals. As Harold Coe was recalling when he spoke here, it was somewhat inconsistent to have this policy of support for the ad hoc tribunals and to not have a similar policy of support for the ICC, considering they were all serving the same broader objectives. Specifically with respect to the crime of aggression, the U.S. wanted to make sure that uses of force that it considered to be lawful would remain lawful. So it wanted to try and narrow the definition of aggression. It also wanted to make sure that there was no spillover effect, that this definition of aggression, even if adopted as is, would not be spilling over into customary law or be used as a basis for domestic prosecutions. In terms of jurisdiction, of course, the U.S. wanted to make sure that U.S. officials would not be subject to the court's jurisdiction without U.S. consent, at least in the particular case, to try and also limit the exposure of coalition partners to this aggression regime, and also to try and preserve, again, the Security Council's prerogative. The paper then goes into a discussion of the evolution of the negotiations and the outcomes of the negotiations. One thing that struck me on the definition issue was the U.S. circulated its understandings, and at least one delegation expressed some indignation, just felt, how dare this non-state party come in at the last minute and try to impose its will on this definition that we've been working on for a decade. But nonetheless, when there was an informal meeting called to discuss the U.S. understandings, the room was packed. Every delegation was there. It was standing room only. Of course, the main session was still going on across the hall, and there were maybe 4 people in the room. So it was just astonishing to the extent to which the U.S. was commanding an audience in Kampala. So the ASP was very keen to hear what the U.S. had to say and was very receptive. I mean, some of the understandings got in. Some of them did not, but the U.S. delegation botched the negotiation a little bit. They made a few errors in the informal. in any event, so they did lose out on a couple of the understandings, but I don't think it was a major loss from the U.S. perspective. Understanding that the definition itself was not going to be reopened. Ultimately, in terms of jurisdictional triggers, we were left with a very consent-based regime. There's an opt-out for states parties, a complete exemption for non-states parties. So in terms of seeking a consent-based regime, the U.S. could not have done much better than what it got. And I think this opt-out for states parties is with the idea that all states parties will accept the amendment and then avail themselves of the opt-out so that you preserve the unity of the statute. That seems to be one of the benefits of having this opt-out regime in the amendment. Let's see, 121.5 second sentence. There were all sorts of refrains in support of the so-called negative understanding of 121.5 second sentence. Basically that when the 121.5 amendment procedure is used, both states parties and non-states parties get an exemption if they've not consented to that particular amendment. That's reflected in the preambular text, I believe, of the amendment to Article 8, the War Crimes Amendment, and it's also essentially expressly embedded in the text of the aggression amendments, which again provide for the opt-out and for the the exemption for non-states parties. The Security Council still retains an important role in the aggression amendments. It doesn't have exclusivity, but nonetheless, it plays a role in any aggression prosecution. Ultimately, I guess, where do we go from here? On the definition issue, the U.S. can continue to try and narrow it, but it has to do so in a good faith way. What was coming across at Kampala was that the U.S. was seeking to narrow the definition, essentially to remove it from the statute, to make it impossible for there ever to be an act of aggression. One of the understandings was that the criteria of character, gravity, and scale would each independently have to be sufficient to constitute a manifest violation of the Charter, which is impossible. You could never just have one, just have scale be sufficient without reference to the other circumstances surrounding the act to constitute the crime of aggression. So if the U.S. does want to continue to try and narrow the definition, it should do so in a principled way, in a good faith way, and articulate what it is that the U.S. thinks should be prohibited, not just attempts to narrow the definition for the sake of narrowing the definition. There has to be some articulation of this is the particular evil that should be prohibited, and this is why the definition should be changed in order to capture that conduct. In the absence of that kind of showing, it just reeks of bad faith. I would say the same thing with the push for Security Council exclusivity. Again, the delegates at Kampala and in the ASP generally are wary about the Security Council because they believe it's not acting in the interests of the international community, that it may act in the interests of the international community, but that the P5 will sometimes act in their own individual national interest. And of course, experience bears that out. So they're not, on another planet thinking this. So I think the U.S. should give up on this push for Security Council exclusivity in this domain. Of course, preserve the importance of the Security Council. It has a vital role, an extremely important role in the collective security arrangement of the UN Charter. But in the realm of international criminal law in the strict sense, the battle to have Security Council exclusivity has been lost, I think with good reason, and the U.S. should accept that. Finally, on continued engagement, the U.S. concerns were met and addressed at Kampala. There was an atmosphere of wanting to hear U.S. concerns, recognizing that some of those concerns were legitimate, that they're well thought out, that the State Department lawyers are generally pretty good and they might have something worthwhile to contribute to the discussion. I think the good faith shown by the ASP, it was clearly demonstrated that the ASP was not out to get the United States, should take away from some of the fear that the U.S. has had towards the ICC. And the U.S. should recognize that the ICC is a very worthwhile experiment. Yes, it's still young, it's having its growing pains, but it's an experiment that's worth supporting. And for that reason, I think the U.S. should consider ratifying the ICC statute. The ICC is designed as a system. If it's ever going to be effective, if it's ever going to fulfill its potential, it has to be treated as a system. And that the U.S. recognizes that the objectives of the ICC are good. It should participate in this system, support this system, at the same time minimizing risks and From what we've seen at Kampala, they've done a great job at minimizing risks. If it wants to further minimize risks, it can avail itself of the aggression opt-out, also the war crimes opt-out under Article 124, give the court more time to develop, see the court's jurisprudence and its first judgments. And that breathing room, especially also with the aggression amendment, you have at least another 7 years before there's any possibility of the aggression amendments being activated. Support the court, become a party to the statute, avail yourself of this breathing room, and hope that this experiment is a success.
Okay, well, thank you very much to David and to John. I'll open it up to the audience for questions, though I have several I'd like to pose as well. Are there any from our audience, for our last two speakers or any of the speakers? John.
Thank you. I'm John Washburn with the American NGO Coalition for the International Criminal Court. Two quick questions. One is this has to do with the question of ASPA and Congress. Is the U.S. administration better off seeking repeals of portions or all of ASPA along the lines that Professor Van Schaak recommended, running the risk of, as one of my colleagues put it, stirring up the animals in Congress on this issue, arousing confrontation, drawing congressional attention that may be better not to have drawn? Or is the administration better off not to do that and to make the absolute most of all of the leeway, exits, and waivers and the Dodd Amendment in ASPA, something which it has started to do and which so far has not drawn any negative attention? My second issue has to do with the question of policy. Is the U.S. better off with this accumulative approach to policy, in which we are told that, well, we have a policy because you can just put all of our official statements together and that makes a policy, and of course that's particularly nice for the two principal people in the Department of State who are making those statements? Or should the administration look again at its decision not to have a formal policy? The problem here is that without a formal policy, you don't have a basis for creating the mechanisms, and certainly in making them permanent, that some of you have called for handling various parts of the ICC relationship. You don't have the kind of machinery which makes it possible to act responsibly, promptly, and with forethought to the inevitable negative things from the U.S. point of view that is going to happen at the ICC as a permanent institution. Someday, probably not very far in the future, something is going to happen at the ICC that will really upset the United States, be regarded as negative to U.S. Interests, and will have to be dealt with. If you don't have something permanent in place to cope with that, are you running an unacceptable risk of your future relations with the court? Finally, there is the whole question of relating a policy toward the court, and I mean here again a formal policy, which is directly related to an enunciation of American national interests and the details of American foreign policy. We get, at a fairly high level of generality in these statements that I've mentioned, references to these connections, but there is not a formal, effective, clear interaction between them. And I think that we need to look at, should we look at the question of whether a formal policy, despite the difficulties in arriving at it, would be worth making the effort, and for us in civil society to make the effort to push the administration to do it.
Okay. John, thank you. Who wants to jump in first on ASPA and articulating a policy?
Right. I'll just, if that's okay.
Great. Yep.
Well, John, thank you for those, as usual, very relevant questions. I think on the ASPA issue, while one theoretically would love to see repeal of certain provisions, particularly the Hague Invasion and non-cooperation provisions, those would be the two that I would consider. First, the Hague invasion optically makes a big difference with other countries in terms of their relationship with us, and the cooperation one is just a pragmatic one. We actually do, even on a bipartisan basis, I think there's a great deal of interest in supporting the court in certain of its African investigations, whether it be Darfur or otherwise, and why we have to skip around that issue and try to avoid it, as opposed to just have the freedom to launch into those cooperative relationships when it's in our national interest to do so, and you can write it into the legislation that it has to be in the national interest to do so, is unfortunate. But particularly with the new composition of the House of Representatives, it may in fact be a very, very difficult set of amendments to get through now. So yes, I think a lot of smart thinking about waivers, data amendments, cooperative ventures that don't cross the line with ASPA. That's a sophisticated analysis that I would certainly think, if it's not being done, should be done. On the formal policy issue, yes, I actually think there should be a formal policy statement, but perhaps tactfully it should not be one that is blared into the world, but rather emerges through the normal processes of, for example, UN discussions, such as in the 6th Committee. We have to deliver a statement that usually relates to the ICC, and that's one place where a very cogent, formal policy statement could be delivered along with other countries. We're not trying to trump them. We're just aligned in the same process of stating our views about the court, and that could be a possibility. I do say in my recommendations in the chapter here that I think it would be very useful for the president to put a few lines into some speech somewhere that embraces essentially what has transpired in Kampala, that this is a good beginning, that the United States wants to remain engaged with other countries on working towards what will emerge in 2017. In other words, just something from the top guy that would give our teams of negotiators in the future a little bit of leverage and greater gravity of intervention if the president himself would say something to that effect. And finally, well, I think that's it. Your third question was really formal policy again. I might say this to my good friends at the American Society of International Law, that, AMIC serves an incredibly important function in the United States, from the grassroots all the way to the leadership in Congress and in the executive branch, in terms of getting just the objective story of the ICC out there in front of people as an educational exercise. And I hope we can find a way over the next year to ensure that AMIC can continue its extremely important work. We need that grassroots communication. We need people talking in American Legion halls and debating these issues. And that's what AMIC is actually so good at doing.
Okay, thank you very much, David. Do any of the other panelists disagree with that answer or have something to add, or should we go back to our audience for any other comment or question? Are there any? I have a question maybe for you, David. There is. Good. Oh, good. Oh, wonderful. Yes, please.
Hi, I'm Ariella Blatter from Citizens for Global Solutions.
I can't hear.
I'm Ariella Blatter from Citizens for Global Solutions and American University. David, you touched on this, and John, you may want to also comment, but my question, naming names, regarding Japan's statement after the adoption of aggression in Kampala. Can you hear me, David?
I just can't hear. I'm sorry.
Okay. Is that better?
Well, you got to shout into that mic. Yeah.
Oh,
I don't know if it's on.
Let me try talking very loud. Sorry, everybody else. It's about 121.5 regarding Japan's analysis that that it was cherry picking from the relevant provisions. And then later, more recently, the last couple of weeks, Harold Coe reiterated some things regarding 121.5. And I'm curious, going into the Assembly of State Parties next week, what your deeper legal analysis is on the 121.5 questions, where you think where you think the U.S. is, and what you think might transpire in your inner intel regarding Japan's leadership on that issue next week. Could you hear me?
I would say Japan's leadership, and of course you've outed the case, is extremely and very influential, and not without some reason. You know, Japan made gutsy moves. In the dead of the night on the last night, it expressed its concerns, but then went ahead and joined the consensus, but said that this is an issue that we've got to deal with in future sessions of the ASP. So here we are. And I think what they have recommended, I would find very satisfactory, quite frankly, that 121.5 is the lex specialis provision of the Rome Statute that trumps Article 12 for purposes of establishing the jurisdictional reach of the crime of aggression over a state party, as well as, quite frankly, under the terms of what was accomplished in Kampala, a non-state party. So I would just argue that once a state ratifies the amendment under 121.5, it is covered by the amendment, but of course it does not become an operational amendment vis-a-vis that state until you achieve that 30-state threshold that is required. I don't know if Japan, it'll be very interesting next week, whether Japan will go back to some of its original positions regarding 121.4 that it uttered at times during that second week of Kampala, but which it has not, as far as I know, been emphasizing recently. I stand corrected on this. But of course, they had a great concern that the 30-state rule was trumping 121.4's 7/8 rule. And yet, you know, when you compare that to 121.5, then you get into a confusing analysis. And it may be that by this stage they've said, well, it really makes no sense to argue 121.4 because we want to sustain the sanctity of 121.5, so let's not muck it up and just ensure that a state is going to have to ratify that amendment, and then after ratifying it, it has to lodge its declaration of non-acceptance if it does not want to be covered by the amendment. In other words, a state party that does not ratify the amendment presumably will not be covered by the amendment, but if it ratifies it, then it's got to be sure that it delivers that declaration in order to withdraw itself from the coverage of the amendment.
Okay. Any other questions from the audience? Edwin.
Take more than my share, but since no one else stepped forward. Could someone just refresh my memory as to how or did the Assembly of States Parties address non-state actors who commit elements of the crime of aggression, and why did they do what they did or did not do? Particularly given that it seems to me that the focus in the IHL world today is on basically non-international armed conflicts.
John, you
I
want to take it?
can barely hear that. Maybe John should take that question.
Yes, I think that makes sense. John.
Yeah. Well, I didn't follow the ASP negotiations on this issue, but I presume it's just because the jus ad bellum doesn't bind non-state actors. It operates interstate, and therefore they just stuck with the traditional international law notion of jus ad bellum.
Mike, did you have something you wanted to add on that? The question.
view of non-state actors in committing these acts is not important enough to be addressed in an international conference of this importance?
No, I don't think it's about the importance. It's a question of international law.
But why couldn't you have adopted a definition of a crime that did touch on them?
You're saying create a new rule of international law to prohibit aggression by non-state actors. I guess the belief was, A, it's already a crime under the domestic law of every state, so it's already clearly criminal, and B, it would probably also constitute one of the jus in bello crimes or a crime against humanity. So it's already pretty much covered by the statute. I assume, again, I didn't follow the negotiations in the ASP, but that would be just sort of my standard international lawyer's answer.
Mike, do you have another take?
Yeah, I think it's useful to remember in this context that the discussions about both prongs have been underway for nearly a decade. And so there was a pretty strong undercurrent of consensus that even though what you raise is, I think, a critically important issue in the world today, and one that we can have other focuses on, that after a decade of debate, delegations simply weren't prepared to open that up, which leads me to something that I think is really important for us all to realize, is that Kampala, everybody focused on Kampala, looking at the 7-year review conference and all, et cetera. All that really did was to open the floodgates now for future actions by the Assembly of States Parties to change the statute as needed and to diplomatically engage. And so to that extent, what you raise, I think, is a critically important issue, and that's why this concept of principled engagement is so important, that the United States has to remain engaged to shape prospective amendments. On that particular issue, I think there had just been too much diplomatic water under the bridge to reopen that in Kampala, but that's not foreclosed at all going forward. And I think that to the extent that it does affect the interests of other states' parties, we absolutely ought to be engaged in that issue.
I'm sorry, but I just find it hard to accept that in 8 years of negotiations, during which NAICs were front and center in all international war crimes issues, that one had to rely on a 1974 UN General Assembly resolution.
I agree.
A good topic for another ASIL forum, and we've got 7 years of material here, I'm sure. Our lunch is served. I don't want to shortchange our presentation by the folks from the Victims Trust Fund, so we'll take a break and get yourselves a plate and mill around. And Peter and Kristen, maybe you could stand up and raise your hand so that those who don't know you will know you. Peter DeBond and Kristen Kalla from the Victims Trust Fund, if you want to try and buttonhole them over lunch.